I want to welcome everybody to the Beverly Hills Bar Real Estate Section's November program. My name is Howard Gould. I'm co-chair of the real estate section, and we're very excited to bring you a program with two of the top mediators in the Los Angeles area today. Before we begin, let me mention to you that our programs after the first of the year, January, February, March, are going to be a review from a CAR lawyer of the new CAR residential purchase agreement, in which they've changed the format and made a lot of changes. We're going to have a program on California real property taxes and our annual review of the new California case law applicable to real estate matters. The other thing I want to mention is that I will be looking over the chat for questions. I prefer to use the chat over the Q&A if you could, and we will try to answer all the questions that come up for us. It's my great pleasure to welcome the Honorable Carl West, former judge of the Los Angeles Superior Court. Judge West spent 18 years on the bench, the last 10 years all in complex civil courtroom, which, as I'm sure everybody knows, handles some of the much more complicated cases, often multi-party cases, often matters with complicated procedural issues. Judge West is currently with JAMS and is one of the busiest mediators around. Tells me he's currently booked about through May. Judge West, while in private practice, in terms of real estate matters, worked on some real estate development matters, and his expertise includes construction defect matters, business commercial claims, environmental mass torts, and a number of other areas in complicated matters that come up before judges and mediators. He has been with JAMS since approximately 2011, and as I mentioned before, is extremely busy. He's currently doing only mediations, although previously he was also doing arbitrations, and I have had the privilege of working with him in a role I know he won't accept again as a provisional director, but his experience is very broad and is sought after by all sorts of people in LA who can find time on his calendar. Our second panelist I have known probably 35 to 40 years. Robert Mann has been known for a very, very long time as one of the more knowledgeable real estate and construction lawyers and mediators in town. He's been in that practice for over 40 years. He's acted as a construction management supervisor for some clients. He has over 50 published articles about arbitration and mediation, which Judge West tells me he enjoys looking for and reading when those come up in the Daily Journal. Among the real estate areas where Robert tends to be most active are non-disclosure cases, broker malfeasance issues, escrow issues, title company issues, commercial and residential lease disputes, and believes he's probably resolved more real estate non-disclosure disputes than any mediator in California. Robert's educational background was Stanford U and Santa Clara School of Law, and Judge West attended Occidental College in Loyola. We're going to run through in this program a number of the sort of areas where questions come up in mediation, somewhat maybe sequential in terms of how they come up. And so I think we're going to start off with the issue of what is a sign that the case is not really ready to mediate. Robert, you want to start us off?
Well, timing of mediation is always important. But I think I was thinking about this question, Howard, and it occurred to me that sometimes the approach or the attitude of the lawyers and the parties is much more important than the actual timing of the mediation. If the lawyers and the parties have an approach that basically is, let's get the case settled, I personally believe that timing can be just academic. We'll figure it out and get the case settled no matter what the timing is. So I always wonder, what do people really want to do with this case? Do they really want to settle it? If they do, great, we'll figure it out. But in terms of timing, when is a case to premature? Depends a lot on a whole bunch of factors. There's a lot to be said for an early mediation before everybody has spent time and money running around in discovery and motion practice, especially in a case where there's no attorney's fees provision. So even though maybe the facts have not been fully developed, an early mediation might be very, very beneficial. The flip side of that argument is maybe there's an important deposition that's got to be taken in a case where the facts really matter. Not all cases are fact-driven. Maybe there's an important motion that's got to be heard. If that's the situation, maybe the case is premature. Although, as a footnote to that argument, sometimes if there's a pending motion, it's an ideal time to mediate the case with the ruling hanging over both parties. Can be a very strong motivating factor for settlement.
I share most of Howard or Robert's thoughts on this. I think traditionally we always looked at mediation as being most effective when the parties were up against the wall and nothing settled the case like a trial date or being right on the precipice of trial. I think in today's world, where probably 95% of the cases that are pending are mediated at some point during their lifespan, we see a lot more early mediations where the case might not be fully developed, but either the court is ordering them to mediation before they'll have a trial setting conference or before they'll set a trial. And my sense is that, much as Robert has suggested, if the parties come in and are desirous of making a deal, we should have a pretty good track record and a pretty good batting average because both sides would like to have the case resolved. In the type of litigation that I see, the parties are looking at spending literally hundreds of thousands of dollars, if not more, in engaging in the initial rounds of mediation and class certification, other things like that. And in the real estate context, if you have a large development that or a construction defect case, the cost of moving those forward is substantial. And so I think early mediation and the timing is something that maybe a mediator can help the parties, even if you're not successful in resolving the case, in kind of developing a game plan for how to approach the development of the case, maybe some limited and some directions from the mediator to suggest that if you could do some discovery on these issues or on those issues, maybe teeing up some dispositive motion. If it's a contract dispute, is there a key clause that is going to make it go one way or the other? And I totally agree with Robert. Once those issues are teed up and fully briefed, sometimes that's the best time to try and resolve the case before someone tells the parties this is the way it's going to be or sets it up for an appeal and other issues. So timing is important, but I don't think as important as it used to be because mediation has become such a mainstay of the litigation process.
One of the interesting points I think that came up in our preparation is that sometimes the dollar amounts can change if you're waiting. The damages can change. There's the interest factor can sometimes be significant. And I'm not sure the lawyers that we always think about that something new could happen that's going to change the amount that the other side is asking for or willing to pay. Sometimes it's the financial condition of the defendant can deteriorate while you're waiting.
That's my, better be careful what you wish for. If you want to take a real hard line and you say, we're going to engage in discovery, sometimes the other side can find a pearl of wisdom or something that emboldens them instead of humbling them, and the price of poker can go up. So that's always a risk in these cases. And so there's no time like the present.
Another interesting point I think Robert brought up, and perhaps you can comment on, is what about mediation as sort of a discovery tool?
Well, that's a very good point, Howard. I think that my experience is that mediations come in two flavors, tee-up days and money days. As a kind of a thought about that, and I'm getting to your point in a minute, I will sometimes reach out to the lawyers before the mediation and simply ask them, what's the goal? Is this going to be a money day or is this going to be a tee-up day? And if they tell me this is an information gathering exercise, then I know how we need to spend our time at the mediation. There are lots and lots of mediations that are just information gathering devices. And I think that in the past, people were critical of that, critical of the idea of we're here to settle the case. We're not here to get free discovery. And I'm not going to give free discovery, although oftentimes the person who says I'm not going to give free discovery actually wants free discovery from the other side. But as time has gone on with this and my own experience with mediation has evolved, I actually see nothing wrong with using the mediation process to learn facts and arguments, because not every mediation settles on the day of the mediation. Sometimes you've got to just set it up for a successful mediation in the future. I do believe that mediation is the most effective, cost-effective, and efficient form of discovery known to man. And in the cases where we need to sit down and talk about what happened here and try to figure it out, in 2 or 3 hours or 4 hours of those discussions, you can accomplish what would otherwise take you months of interrogatories and document productions and depositions, and avoid the, as Judge West was saying, the hundreds of thousands of dollars that would cost. So I am not critical of that effort, with one consideration, that everybody needs to be on board with it. Because if one person is not on board with it, one party's not on board, they're going to be upset.
Yeah, I don't quite look at the initial approach to the mediation as either a tee-up day or a money day. My sense is, and I'm an eternal optimist, I kind of have my glass half full all the time. So I always go in the morning thinking, no matter what they said in the briefs, there's a middle ground here, or there's a soft spot that I can poke both sides and we can get something done. If in the later morning or at some point during the day, you realize it's just not going to happen, then kind of my sense is, I try and tell the parties, I want to give you all the bang for your buck you can get. You've got me here for the day. I'm going to do everything I can. So maybe I can help you manage this litigation a little bit, or focus on some issues that the other side is very skeptical about and that we need to develop so that we can make more progress in the settlement process. And so I may lay out a schedule for them. I'm seldom looking for another day of mediation, so I don't say do these things and then come back, but I do kind of set a schedule, and then I'll follow up with an email and say, did you get the information that the other side said they were going to give to you? And are we in a position now to revive our discussions? And then work informally with people via email and conference calls. And I find a lot of times just holding hands and helping people move the discussion forward by kind of informal discovery or directed disclosures can be very productive.
Can you tell us, what do you see lawyers doing right and maybe not doing so well in preparing themselves and their clients for the mediation, or preparing the arbitrator, or mediator, excuse me?
Well, you want me to answer that one, Howard, first?
Sure, go ahead.
What do I see them doing right and not so well? The first thing is the basic attitude toward the mediation. Pardon me, at a very, very basic level. I have a theory about mediations. I call it the bonfire theory. Clients are often in mediation like a little burning bonfire. And the lawyer standing next to the bonfire can take two approaches. The lawyer can throw gasoline on the bonfire, or the lawyer can try to put the bonfire out. So when you're preparing for a mediation, unless you think about it as I'm going to try to put the fire out through various means, that case is not going to settle. Because if all you want to do in the mediation is throw gasoline on the bonfire and make it burn brighter, it's not productive. So the first question in terms of preparing, you have to ask yourself the question, what do I want to do here? Do I want to settle this case, or am I just going through the motions, or am I trying to accomplish something else? So let's assume, just for discussion purposes, that this lawyer really wants to get this case settled. Okay, so what's the best way? Well, I think it's essential. What do I see people doing right and not so right? The right approach is, if you want to call it that, it's a whole bunch of things. First of all, you got to prepare the client. And the essential, I think, thing to prepare the client is to make the client understand that the process of mediation and settlement is going to include compromise, sometimes painful compromise, frankly. I'm not saying that everybody leaves unhappy and all that stuff. I don't really believe in that philosophy. I think people leave happy most of the time. But you got to compromise. And you got to think think about and talk to the client about logistics. It's going to be a long day. There's going to be a lot of sitting around. You're going to have to be there the whole day. You got to have a decision maker present. You can't expect to make a phone call to somebody who's not in the mediation for advice about what to do. It's not productive. It's usually destructive to the process. You have to understand that you cannot undercut the mediator by saying things like, he's just trying to scare you, or he's going to try to scare you, and don't listen to him. If you're going to make those kind of remarks, why are you in mediation? It's not helpful. You have to have a good brief. It's got to be thoughtful. You've got to prepare for other eventualities that might come up. And maybe most important of all, you have to be willing to open your mind to the idea that you're going to hear and learn things about your case that you may not like. And you've got to be able to take them in and process them and not rebuff them and refuse to listen. That is such a key element to a successful mediation and thorough and good preparation. And I guess the last thing is you have to have realistic expectations. And you have to communicate realistic expectations to your client. If you have created unrealistic expectations, you have done a poor job of preparing for the mediation.
Okay, I think Howard, the question I got was, what do they do? People do right, and what do they do wrong? And the first thing that I think a lot of lawyers do wrong, and this is a function of the fact that people don't always exchange mediation briefs, so that you're not sharing yours with the other side, and they're not sharing theirs with yours, which I actually think in many cases, the transparency of doing that makes the mediation much more efficient and effective from the get-go, so that I'm not spending time kind of dancing around what each side's position is. But what lawyers do wrong is they give these excellent briefs that are all one-sided to their client, and the client reads the brief in preparation for the mediation, and they are convinced that they have a dead bang winner, that this case can't lose, and for all the reasons put forth in that brief, that they should take a very hard line, and that they're going to recover everything they want. Well, there's no such thing as a dead bang winner in our world, and particularly in the litigation context. I'm fond of telling people, if you have a dead bang winner, it might have a 70% chance of success, because even the best case can go awry. And so clients need to be have the briefs explained to them and say, this is an advocacy piece. We're giving it to the mediator to give them our best view. And some lawyers in their briefs will realistically assess both sides of the equation and talk about the points that aren't so strong for their case, but most don't. And so you need to prepare your client to come into the mediation, understanding that it is a process. It is going to require some compromise on both sides to achieve a deal, that deal probably will be in your client's best interest, given the context of the ongoing litigation, the time that may be spent, and the risk that is inherent on that. And I don't think all the time that is fully explained. And so once you're in the mediation, I think I tell people every day, I'm going to tell you some things you want to hear and some things you don't want to hear. Don't take anything personally. I'm also not clever enough to keep too many stories straight. So I tend to tell people in both rooms more or less the same thing when it comes to what I'm thinking about the merits of the case, or the likelihood that one side or the other is going to have a stronger position on certain issues. And I think having that out on the table in both ways, I'm not, I was never fond of the mediator that came in and just beat me up and told me all the bad things about my case. And, I just don't work that way. And I think preparing your client to look realistically at the pros and the cons will help the process. And I also think telling them that this is more of an art form than a science, that you need to be engaged, you need to listen to the mediator. And I always will say, if you need a little time, you take your lawyer's advice, but I'm counting on the lawyer to convince the client to work with me to get something done. And so you need to be an advocate for the mediator in terms of helping move the process forward.
It sounds to me like one of the suggestions you would likely give is that not only should you exchange briefs, but you need to make certain that your client sees the other side's brief. And probably,
it's very important that they not just see a one-sided. And I encourage people to exchange their briefs, and I tell them, if you want to send me a confidential separate letter brief, send it to me. I'll read whatever you give me. And if there are aspects of the case or your defense or your affirmative case that you don't want to share with the other side, just give it to me in a separate letter. But putting these things out on the table and letting the clients appreciate that there are two sides to the dispute usually is pretty helpful.
Any suggestions about what to do, or perhaps more what not to do in your mediation briefs?
Yes. By the way, I should say, I agree with what Judge West is saying about exchanging briefs, and the idea of sending that opposing brief to the client. It's great. I don't think it happens very often, but it's a great approach, and it's a great idea. I completely agree. Well, what not to do in briefs? Well, first of all, if you mediate cases 4 or 5 days a week, there's a lot of reading to do. And mediators, we try to devote as much time as humanly possible to these cases. But when I get a brief that's 50 or 60 pages and it's got 300 pages of exhibits, I have the same reaction, I think, as any human being would have. I would look at it and I kind of groan and I say to myself, I got to read this whole thing, but I wish they had sent me 15 pages instead of 60 pages with 300 exhibits. And by the way, if I get 300 pages of exhibits, I'll usually send an email to the lawyer saying, do you really want me to read these? If you do, I will, but do you really want me to? And invariably, I will get an email back that says, no, just have them available in case we need them at the actual mediation. Now, having said that, so what to do and what not to do? Don't make them long. If you can't tell a good story in 2 or 3 pages, you probably don't have a very good case. And I really mean that. A good story can be told in the first 2 or 3 pages. Don't give me the pleadings and the discovery responses and the motions. If there's something important in the pleadings, just summarize it. We have a claim for X. Don't give me 45 pages of interrogatory responses. Just tell me that the plaintiff admitted away part of the case in this interrogatory response. That's really what I need to know. Don't give me a bunch of attacks on the opposing lawyer. It doesn't usually do a lot of good to demonize lawyers and parties on the other side. It doesn't help us settle the case. And, you probably wouldn't like it if they were demonizing you. What's good? Every case has a backstory. There's something going on. This happened because of something. It's always important for me to know what the backstory is. It's always important to know, have there been settlement discussions? Why did they fall apart? How did they fall apart? What was the last offer and demand? That's really important. And then at the end, a little hint about what are we going to do in this mediation? You know, we'd like to settle the case in this range of numbers. We need this kind of relief. There's some special thing in this case. In addition to some dollar figure, we're going to need something else so that I have some idea what the goal is, and then we can work efficiently to that goal.
Yeah, I totally agree that keeping them simple is better than these really lengthy briefs. I'll add to the notion, and I get large briefs all the time with lots of exhibits, and it's been a pet peeve of mine since I was on the bench. If you're going to give somebody 300 pages of exhibits, one, put it in a single PDF, and two, bookmark it so that as I read the brief, I can go to a bookmark and I can look at the exhibit you're talking about. Because if you give me 300 pages of, just continuous PDF, and I have to scroll through it to find what I want to read when I'm reading your brief, I'm not going to do it. Or if I do it, I'm going to be irritated, and there's no reason irritating your mediator. I think giving the basic case, not being overzealous. I tell people every morning I should be schizophrenic. I read these damn briefs every night, and there's not an ounce of merit in the plaintiff's claim from the defense point of view, and there's no defense to the plaintiff's claims in the plaintiff's point of view. Be a little more realistic. The world isn't as black and white as that, and give the mediator a sense of what I call it an ounce of candor, and I usually don't get it until sometime mid-morning. But if you can give them an idea, as Bob says, about what your expectations are, what would be a successful mediation. We're not looking for your bottom line, because good mediators' job is probably to push everybody over their bottom line a little bit, but we are looking for a sense of, do you have reasonable expectations? And what are your goals? What are the key issues that you have a problem with? And be upfront. I used to say that in briefs for motions. I mean, don't hide the ball. If it's going to come up and bite you in the ass if you're not careful. So you may as well put it out there. What are your weak spots? What are your good spots? And then don't be quite as zealous in your advocacy in a mediation brief as you might be in a motion for summary judgment, because we're looking at it on a more level playing field to try and find that middle ground where we can get something done.
Howard, what Judge West said just triggered something. If you wouldn't mind, can I make one more quick comment on that?
Of course.
Under the heading of what not to do. The brief, if you're dealing with a mediator who doesn't know you, it's the first time you're going to show up with this mediator. The brief is your first opportunity to gain or lose credibility with the mediator, which is extremely important. So under the heading of what not to do, don't send in a brief that's full of typographical errors, because I look at that brief, I'll just be as transparent and candid as I can possibly be. And I think to myself, what kind of a lawyer am I dealing with here? He didn't even, or she didn't even review this brief to make sure it didn't have typos. The reason I'm saying this is it's in essence, it's a trust factor. That lawyer is going to come into the mediation and make arguments to me and want me to respond to those arguments. And I'm thinking, do I want to trust this lawyer or not? And that fact, that lack of attention to detail in the brief alone can destroy the whole thing from the beginning and make the mediator mistrust the lawyer that he or she is going to see the next day.
Once you're in the mediation, or perhaps as part of the preparation, what are the things you see that keep the parties, the clients, engaged or not engaged as you're moving forward?
Judge West, do you want to start on this one maybe? I had the last word in on the other one, so.
That's all right. And Howard, the question is, how do you keep people engaged in the process?
Yeah, do you see sometimes people are zoning out, or that they aren't giving you the attention that's necessary to move things forward? And what do you think causes that, or how do you get around it?
Well, I don't see, the mediation as much as a structured process. I see it more as an art form, and it's really a people business that we're in, at least from my perspective. And I know there are people that write down the time, the hour and minute of every offer and every demand. I know people that look at it as a chess game and that anticipate the next move by the other side. I'm not that. I'm a country boy from Pasadena, and I'm not that sharp. And I don't think it's not rocket science or brain surgery. So my goal, and when I see somebody that's getting frustrated, and I may frustrate people, and the biggest thing a mediator can do wrong, this isn't just about what lawyers can do right or wrong, is be overzealous and too judgmental, so that you turn off the lawyer or the client in that room and they say, who is this guy? I'm not listening to him anymore. I mean, he's on the other side. And I start out every day telling them, I truly don't have a dog in the fight. I'm going to tell you some things you want to hear, some things you don't want to hear. Don't take anything personally. And I tell them, I'm at the agent stage. You can tell me anything you want. You will not hurt my feelings. So don't be afraid to come back at me if I'm suggesting something that's I've learned from the other side. I tend to believe everything I'm told in the process. And I know it can't all be true because I'm told things in each room that are 180 degrees apart. And so if I relate something to you that I learned from the other side and it's not true, just tell me it's not true and I'll believe you and we'll move forward on that basis. But, I don't have a problem keeping people engaged, and if they don't nod off in my mediations. So I'm not sure that that's a big problem, but I think it's just a process that you learn as, your people skills. And that's a lot about what we do, is learning how to read the room a little bit, read the mood. And I can tell when somebody's really frustrated and they're getting pressed, and they've put their last dollar on the table and they're not going to be, they've kind of drawn a line in the sand in their mind. And that's always a bad thing. And whether you draw a line in the sand overtly or in your mind, or you throw down the gauntlet and say last, best, and final, 9 times out of 10, the damn gauntlet hits your foot and you got to crawl over the line in the sand. And so I warn people, just keep an open mind and work with me and we'll see where this goes.
Why, can you give us some idea of the cases that don't seem to get to the finish line and the reasons you see them not settling? What's the biggest impediments? And is it counsel? Is it the clients?
Want my comment on that, Howard? I'd be happy to.
Sure.
Sometimes it's the client, sometimes it's the lawyer, sometimes it's both. I'll give you a short list of why cases don't settle. In no particular order of importance. Clients sometimes are not emotionally prepared to make a decision. They just can't decide. Maybe they're indecisive just by character, or maybe there's some outside influence that makes them undecisive or indecisive. Sometimes clients simply, this sounds strange, but I see it all the time. They don't want to settle the case because they don't want to give up the fight. They're emotionally attached to the dispute. It's such a big part of their life that they're worried about what's going to happen after it's over. Of course, sometimes the lawyers don't want to settle a case. Sometimes, I hate to say this, for economic reasons. That happens. I mean, let's be blunt about it. Sometimes the lawyer has overpromised the client, and then they come to the mediation and they're faced with reality and they suffer from reverse sticker shock. That happens all the time. And then the role of the mediator, you spend so much time trying to either raise expectations maybe in the defense room or lower expectations in the plaintiff room. Sometimes it's just logistical. There's a decision maker that's just not there. Sometimes a carrier representative goes offline. You can't reach them. Sometimes everybody gets really tired and they get too tired to settle the case. I will tell you that a principal reason, I'm using that word for a reason, a principal reason why cases don't settle is a focus by the client on principal PLE and not principal PAL. It's the client who says, I want to teach them a lesson, or I'm going to make sure that they never have the chance to do this to somebody else, or I'm trying to set a precedent. Those cases are, of all of the cases I think that I mediate, that is the single biggest impediment to a settlement, because that person has a completely different agenda that is disconnected from the economic reality of the case.
Howard, can I
Carl, you
comment
have
on-
thoughts on that?
Let me just make a comment. And Bob's last point is absolutely true. I will say that I think there's a difference. My practice is primarily at a corporate level with commercial and more business related disputes. And there is a distinct difference in my view from individual claims where you have two individuals fighting over the boundary line to their residence or fighting over the purchase and sale agreement and disclosures. You get a lot more emotion in that than you do in the business and commercial setting. And the real estate context that I've been involved in, and when I am involved, it tends not to be on a one party versus another, or individuals versus individuals, but rather a development where you have, the investment partnership and the developer. That's a lot more impersonal. And it tends, a funny thing, but I tell people every day, most of my days are spent with people fighting over money. And so the biggest problem and impediment to settlements is getting to a number that both sides can agree on. And in recent times, I call it the COVID discount has struck, and there are, economic downturns where companies just don't have the resources to pay what they might acknowledge is the exposure on their claim. And the plaintiffs have to look at it and say, do we want to stay in this litigation and spend another $500,000 or $1 million to litigate it, knowing that at the end of the road, we may have a defendant that doesn't have the resources to satisfy the obligation in the first place. So those things come into play. I do think sometimes there is a disconnect from reality in terms of being oversold the case, as Bob said, by your attorney, and has told the client you have all of these strong claims. And you really have to have effective mediation, be willing to accept that everything doesn't go our way all the time, and that if we're going to resolve this, we're going to do it as it's a business judgment. It's an economic decision, not necessarily what is right or wrong, and that gets into the principal versus principal. Those considerations have to come into play, and if they're not going to come into play, and you get people that are too strident, it makes it very difficult. And I say you can bleed out slowly, or you can get a deal done today, or in the next couple of weeks if I follow up and we stay with it. But otherwise, you're going to spend a lot of money, and you're still going to have the risk exposure, whether it's the risk of a plaintiff not recovering, or whether it's the risk of the defendant having a substantial judgment against them. And that's why I'd say at least half or 3/4 of my mediations are pretty early in the litigation process.
Robert, and one of the things that you had sent me, you talked about confirmation bias becoming a problem. Can you explain that for us?
Oh, my favorite. So although I'm not a scientist when it comes to mediation, there are mediators who are very focused on the process itself. I'm not. I'm much more informal. I think like Judge West, I think our philosophies are very close to one another. I am, however, a very big fan of a person named Daniel Kahneman, who won the Nobel Prize in economics, even though he's a psychologist, for work that he did on how people make decisions. And in fact, I got to spend an hour on a Zoom with Daniel Kahneman about 2 months ago, which was fun because I don't hang out with Nobel Prize winners very often. So it was quite an experience. So Kahneman talks about what are called cognitive biases. Confirmation bias is one of them. And in mediation, I think the most important one. The second being attribution bias. So confirmation bias is simply a mechanism where all human beings kind of do this. We tend to be attracted to and anchor ourselves to facts and arguments that support what we believe. And we try to rebuff, push away contrary facts and arguments. You see it in all aspects of life. You see it socially, religiously, politically, all these things. So, for example, if you're a political conservative, you might want to listen to Fox News, and you'd rather, stick a pen in your eye than listen to NPR or MSNBC or something like that. So in mediation, what happens, and in lawsuits, what happens is that the natural human tendency to confirmation bias becomes amplified by 1,000-fold. And the effect of it is simple. You'll have a client or even a lawyer, sometimes both, say to you in the mediation some version of the following: look at this mountain of evidence. It only leads to one conclusion: we're going to win the case. So it's confirmation bias that's driving them toward that conclusion. Because, as Judge West said, there's no perfect case. If there were perfect cases, there would be no need for mediation. And perfect cases just don't exist. And so what do we do with the confirmation bias, which is so powerful? It's immensely powerful in driving people's analytical process and leading them to make bad decisions. Here's what I do. I talk about it in a very open way, and I explain what's going on. I find that when you talk about it in an open way, it's like you've kind of raised a curtain and people can see a little different reality. And I try to explain to people whatever biases that trier of fact might have, they don't suffer from the same confirmation bias. They don't go into the trial thinking that one side or the other necessarily is going to win. They figure that out as they go along. So I think it's, in my view, this is a critically important thing to talk about because it leads people to make poor decisions. That's exactly what Kahneman concluded in his research, is that people make poor decisions as a result of these cognitive bias and how they affect people's analytical process.
And you mentioned attribution bias. Can you?
Oh, that's okay. That's my second favorite. Attribution bias is, I'll give you an example, a quick example. Mediation is going to start at 10 o'clock. By 10:30, the defendant hasn't shown up, and you're in the plaintiff's room, and you tell them they haven't shown up yet. And the plaintiff goes on a tirade. Well, this is typical. This just shows you how much they disrespect the system. They disrespect you and me. They're idiots. They're horrible. They can't even show up at the mediation on time. These are horrible people. They're disrespectful, stupid, horrible people. Okay, the reality of what happened is that the defense lawyer had a flat tire and couldn't get the automobile club out there early enough to be at the mediation on time. So what's happened here is the plaintiff is attributing bad motives and bad conduct to the defense team when in fact it has nothing to do with it. And you see it all the time in mediation. People say to the mediator all the time, well, they're liars, they're cheats, they're horrible, they're dishonest, they're manipulating me and you. When in fact, the behavior in the other room has nothing to do with all these things. What's the impact of it? Here's the impact in one sentence. It dehumanizes the opponent. And when you dehumanize the opponent, it's hard to give any credibility to the opponent. So it's just another way of saying, we're going to win the case because the other side is stupid, idiotic, dishonest, manipulative, etc. So that's the force of attribution bias.
What do you do in an arbitration, in a mediation, when you realize perhaps that one side actually isn't honest? And that's what the transaction turned out the way it did.
Well, it's hard. I tell people I'm no longer a judge and I'm not being judgmental and I'm not going to adjudicate your case, but I'm going to give you my thoughts. You're paying me a fair amount of money to be here with you today. So I'm going to tell you what I think. Don't take it personally. Just to touch on one of the points Bob made just now. I can't fathom when people, and it happens almost 3 times a week, one side says the other side's not acting in good faith. That's bad faith. I say, listen, I work with good lawyers. I'm working on interesting cases. I believe what you're telling me and what they're telling me. I don't think anybody's here in bad faith. And it really kind of gets my goat because it is a go-to argument by either, it could be the plaintiffs, it could be the defense. If the defense isn't putting enough money up to make the plaintiffs happy and want to get engaged, then the defense is in bad faith. If the plaintiff is demanding $10 million, and we all know it's probably a $750,000 to $1.25 million case, they're acting in bad faith. Well, it's just the way the game is played sometimes. And I try and diffuse that by saying, we need to get engaged. We need to get into that range for discussion where the rubber meets the road, where both sides are incentivized to make a deal. And don't overreact. Don't be offended. It's a process. But bad faith, that's attribution bias, I guess. The other side's always in bad faith. And it just galls me because I tell them, nobody's here in bad faith. And most of the people I deal with, I mean, you hang around long enough, you deal with everybody at some point in time. I've got a lot of lawyers that I've known for 30 years, 20 years that come back that I regularly mediate cases with. They're not acting in bad faith on either side. And sometimes I'll have that same group of lawyers on both sides and they're pointing the finger at the other one. So that's important to recognize that. To answer your question, Howard, when I have somebody that's dead in the water, that is not telling the truth, and it's clear from the evidence that I've seen that they've got a real problem, I tell them, you can bang your head against the wall, and it doesn't make any difference which side it's on. You've got a real problem here. And I'm not bashful about saying you will be better off in the long run if you get this case resolved. It may be painful. To allude to another comment Bob made about late in the day, I call it mediation fatigue. People get worn down and these are long days. And so if I've got people that are terribly polarized or they're at one another's throats, but I can see that there's a real opportunity to get something done. And sometimes the corporate defendants have to go back to the mothership. There's a process to get authority and they came in maybe with less authority than it's going to realistically take to settle the case. I'll say, let's call a little break here. Let everybody count to 10. If you need to go back and share some of what we've talked about today with your management and then get back to me. And then I try and calm the plaintiffs down because they're saying, oh, they came in with no authority and they were in bad faith. I say, no, it's a process and it happens a lot. Just stay with me. I'm not going to abandon you. I'll be available, any morning after 5 o'clock. You can make a call, you can have emails, you can do whatever you want, but that's the process. And sometimes you have to accept defeat on a one-day basis in order to preserve the opportunity to move forward on maybe a broader scale. But if they're dead in the water, the best thing to do is tell them they're dead in the water.
And I'll be a witness to the fact that if it's after 5 in the morning, you may well see that Carl's working because he sent you an email. He's working all the time. What do you see in terms of sometimes innovative things that have helped settle cases?
Well, there are innovative ways to settle cases, but in business and real estate disputes, they're hard to find. I've settled cases with various what you might call innovative means, among them apologies. This happens every once in a while. I've settled some cases where people have been very well-to-do and they've made contributions to charities in the name of the other person, because everybody recognizes that the other person really doesn't need money. So they say, you know what, give me the name of your favorite charity and I'll write them a big check in your name, your honor. And that happens. Sometimes the parties fear that they're going to have conflict in the future. No matter, even though the case is being settled, they have a fear that something's going to happen in the future. So one, maybe if you want to call it innovative way to do that, is you set up a simple dispute resolution procedure. And you say, look, if a fight breaks out over this, here's the deal. You're going to have a 1 hour or 2 hour telephonic arbitration and somebody's going to make a decision. I'll make a decision. Pick somebody else. It doesn't have to be me. So they know that if a fight does break out, they can get the whole thing done really quickly and really cheaply and not worry about it so much. But you know, look, there's all kinds of ways to do it. There's a very famous case that is taught in a lot of mediation programs where a teenager was killed in a car accident in Santa Monica. And the city and various people had offered the parents a lot of money, but the case wasn't settling. And the parents kept saying, you don't understand how special this kid was. And the case eventually settled because somebody came up with the idea of naming a city park after this kid. And that settled the case. So sometimes you have to reach way outside the envelope to come up with a solution. But, you know, in a distributed bargaining case, frankly, it's often just about the money.
Yeah, the people I deal with aren't as charitable. You know, I don't see, and I do believe that sometimes there are intangibles more often on the individual cases with individuals with emotion, and there's always emotion in a case. I mean, there's nothing worse than an employer that thinks they do everything right for their employees and treats them well. And I tell them, no good deed goes unpunished. You're not in Kansas anymore, Toto. You're in California. And the California labor laws aren't friendly. But I don't see a lot, you know, it's usually economics, but there may be other drivers besides the merits of the case. And I think it's important to recognize that there may be drivers related to the financial ability of the defendant to satisfy a big judgment. There may be drivers related to the timing in terms of plaintiffs that really don't want to, in today's environment, wait 2 or 3 years to get to the end of the road. And some of those intangibles can play a big part in helping to make a deal. And so you want to be creative in terms of suggesting to people what some of these realities are. But there are not as many gimmicks in my world with a quick fix.
Final question for everybody. How do you use the prospect of the trial in terms of bringing parties to some agreement?
Oh, I think it's a great question, Howard. And it's an essential tool, if you will, to get cases settled. It's a mix of things. It's a mix of economics and other considerations. At the economic level, trials are very, very expensive. You've got a complicated case that's going to take a couple of weeks to try. Between the preparation and the actual trial, you're talking about a lot of money. Second, it's the uncertainty principle. There are no guaranteed results in a trial. And this is maybe of anything that we've been talking about, trying to get people to accept that very basic reality is critical to getting a case settled. There's all kinds of ways to explain it. I typically use an example of a case that was lost because a plaintiff was seen by the jurors at a break going out in the hallway, taking a stick of gum out of his pocket, unwrapping it, and throwing the gum wrapper on the floor of the courthouse. And the jurors all saw him do that. and they told the defense lawyer after the trial, after they defensed the case, that they didn't like the plaintiff anymore after they saw him drop the gum wrapper. It's an illustration of the uncertainty principle in trials, how a seemingly small thing that has nothing to do with the merits can create the uncertainty. So the trial, it's expensive and it leads to a very uncertain result. A preferable course of action is to be the master of your own destiny and make a settlement that you control and not leave your fate to that kind of a system.
Yeah, I totally, I agree with Bob. We're up against the trial. I'd say less than 10% of the cases I mediate are have an imminent trial date within 60 or 90 days. And it used to be a lot of mediations were right up to 30 to 60 days before trial. But when you are up there, it's a two-sided sword. Sometimes when you get up to a month before trial, all the expense has been incurred. The prep has been done. The clients have spent an enormous amount of money to get to that point. And sometimes they become more entrenched and more resigned to, we'll just roll the dice, we'll see what happens. Now, if it's a close call, or the worst cases are where there's some question of law that ultimately is probably going to be appealed and that drives this thing, because a jury is going to do some factual determinations, but a party may say, they've made, the mistake is here. They don't have this claim, and we're going to appeal the denial of our summary judgment or the denial of the summary adjudication of these particular claims. Those things, it's not going to be that much easier to settle it on the eve of trial as earlier in the case. But if it's purely factual, then it's a risk for both sides, and they've all looked at it. They're fully prepared, and the lawyers will say, we can't give any guarantee. Those cases can get settled, and everybody, again, it's a compromise. But the more polarized they are, and the less factual, the more legal, or the more philosophical. Sometimes being up against the trial, they've already done everything they're going to do, and they're just resigned to rolling the dice.
There's a flip side to this sort of philosophical point, and something that when I first heard this, I found pretty profound, that I thought I'd like to give everybody and hear if Robert or Carl has something to say about this. But sometimes it's very important that you can achieve things in a settlement that a court can never give you. Right now, I have a case that involves a neighbor dispute, and there's a request for an injunction. Well, you can always define those things in your settlement agreement, and perhaps in ways that a judge isn't likely to do. And
Right.
Sometimes there are things that you can get out of a settlement that the other side's willing to give that are not really part of the lawsuit, or that a court just doesn't have the authority to do.
Well, relief that isn't available in the context of the litigation is often a driver that will help you get things done. Because you say, even if you go forward and win, you can't get this. It's a great point, Howard.
I think
agree.
it's something for the lawyers in the audience to keep in mind, that if there's something your client wants that the other side can give them, but it's not part of the litigation, it doesn't mean you can't get it out of the settlement.
Exactly.
Howard, it's a very, very good point. In a construction case, the essential thing, a 1542 release. If there's a trial, the contractor doesn't get a 1542 release, but he'll get one in a settlement most times.
Yeah, very, very important points in certain contexts. And I have seen cases where that happened, where it was settled because of something that wasn't attainable in the litigation, but that one of the settling parties found valuable.
100%.
I think that's a great final thought. My heartfelt appreciation to Judge West and to Robert for joining us for this program, and for the fun I had in getting prepared, and really appreciate it. And these are two of the best guys in town for anybody who needs a mediator. Thank you both very much.
Thank you, Howard.
Thank you. What a great experience. Thanks, Howard. Thanks, Judge West.
Thank you, Robert.